Okay, looks like we've got that going. Welcome back, everybody. How's everybody doing? How was your weekend? Awesome. Thumbs up. All right. Was everybody able to actually get into um, the the Dropbox with the new link?
I'm in Dropbox now. Don't see it. Maybe I need to request access to it. Let me take a look.
Okay. Okay, and I apologize because I think I said that I was going to put the criminal and the juvenile performance standards in there, and I did not do that until about 20 seconds ago. So sorry on that front. Let's, okay. So where I think we need to start from this is just an outline of the topics. And some of those are going to be pulled from other places and some of them aren't, especially since neither juvenile nor criminal use the rules of civil procedure. And I think that's what you guys use in the PCR realm, yeah? Yeah.
Did
So there
we
might be
miss the OSB, the PCR performance standards from the state bar?
that one was in there, but I didn't put the others that are a little bit more recent because I don't remember exactly how old the PCR ones are, but based off of the shall we say style, I'm anticipating somewhere in the much earlier 2000s, possibly the 90s. So anyway, but if that's a good place for us to start, since y'all have been practicing it, that would make sense to me. This is kind of, what do you guys think is the stuff that an attorney needs to be doing on PCR cases? That's where this is.
Yeah, I think the OSB performance standards are a really good place to start. They seem pretty thorough. They might need like some updating, and I think they're kind of there's more in there than we necessarily need, but
Okay.
I like them.
Let me get this shared. There we go. Get our own.
In terms of dating, it's my understanding that those standards came out of the report to the Board of Governors, which was 2007. So 07, 08. I don't see a date on the standards themselves, but I think that's the general timeline.
Yeah, okay. So we're like 18 years past that. Might be a good way to get some new stuff going. Okay. How do we like then the structure of those performance standards? To give you an idea, the reason why I ask is, oh, hold on, let me share the dependency ones on screen here for a moment, because this is what I am very familiar with, and I think it it captures a lot without going too in depth on individual. Like the criminal one breaks it out by stages of a case and the discrete tasks. The dependency ones, it's more open, and it's more topical, and gets into some of the nitty gritty later on. But the big standards are the ones near the front about just how you do your job, and then gets into the other stuff later. This is not PCR not being my practice area. There may be good reasons why we want to go with a different structure.
I don't mind the OSB structure. I guess in terms of the standard 6.1, the implementation. I think that we could maybe name it something other than implementation. And I think maybe there's some categories that we could break out.
Okay.
But overall, it seems like a good place to start.
Okay. So talk to me more about what you mean by breaking out. I mean, talk to me more about that structure that you envision.
Well, I'm just thinking, let's see here. Let me look at this. I guess that implementation wording was just a little bit confusing when I first glanced at this, but I understand what it's saying now. Looks like, is this how the one that you just showed us, is this how they're set out, where they're setting out kind of the requirement and then how to fulfill that obligation?
So this would be a typical performance standard. So it tells you the first standard is just how you relate to your client.
Gotcha.
And it breaks out between representing a child and representing a parent
Yeah.
because there are a
Okay.
lot of differences there. And then lists out specific actions under each. And there are multiple facets. So like you're protecting your client's due process and other rights. If they are capable of decision making, you defer to them. If they're not, so the set like the second like the B of the B part of the first standard is if they don't have decision making capacity, you try and do as much as you can and give them that option. And then each of those has different commentary and actions as you go through. For the OSB performance standards for PCR, my understanding is that this first one is what we would call and did do
Okay.
performance standard or qualification
That's
standard.
kind of what I understood it to be. And so do we need to put, this information is obviously important. Does that need to be in what we're doing now as well or not?
No, I think we've already taken care of the qualifications, like the prerequisites. That's our qualification standards. And then we would move on to like,
Basically
guess
6.2.
the role. Yeah, would be where we'd start. And does that make sense as a first? I mean, the role of the attorney is kind of the first standard for both dependency and this original PCR one. Ed, you've kind of got a face. I'm not sure if it's a happy face or a.
No, yeah, no, it seems to me maybe it's just oddly worded. I don't think I would word it that way. And I'm wondering, seems more like, I don't know, I get what I'm used to seeing. Well, since we did qualification standard, that's kind of covering what this introduction has. I almost feel like the bigger issue is, caseload standards and workload standards and that kind of thing. But yeah, definitely role of post-conviction counsel strikes me as odd, but no, sorry about that.
No, you're fine.
I agree.
Okay, talk more about that. But again, this is kind of free form. Tell me what you think is appropriate, and we've got springboards for things. But I think I mentioned this last week, a couple of weeks ago, whenever we did the first big piece, like the big work group for Quasi-Criminal. This is the area where we don't expect there's a huge amount of material that already exists. And as you can see, what is already in existence is old and probably needs updating. So I'm giving you guys free rein to like, and we'll coordinate with the other work groups to make sure that things connect well. But you tell me what makes sense in this, especially since this is not my practice area. I would not consider myself an expert on.
And I generally agree with these things. I mean, I've even used these in pleadings to the court, explaining, why I'm taking more time for a case. I think it's more like, Yeah, I don't know. Roll still throws me off, but I think more it's actually rooted in practice standard itself, or actually, yeah, performance standard. That's really like basic performance standard, and then building out from there.
And that's where I'm struggling with it a little bit also. I mean, I agree with all of these things in the implementation, and I'm sorry that I missed a majority of the standards. So I don't know if most of this implementation under 6.2 was covered in the.
Hold on, let me pull up and see if I can find the final draft of the performance standards.
And I don't think so. I think this is more. Not that I agree with the use of the word implementation here. I think it's very confusing, but this is more, I think, actually building on actual practice beyond the qualifications we established.
Yeah, I think the first, like that first standard 6.1, kind of the stuff that's covered in that one in the implementation, we captured in the qualification standards, but I think 6.2 implementation section is like more detailed and more about like, yeah, I think we put this off for performance standard, like performance.
Right. It's the one from February. Not gonna work. Not positive that this is the most up to date, but it's probably close. Come on. Alrighty.
I guess because we're doing specifically Public Defense Commission standards, here under number 3, they talk about appointment or retainer, unless prepared, knowledgeable, skilled. I agree with that. I think in Public Defense Commission, we also want to talk about, caseload and capability and ability would probably fit in there.
Okay. In where? Like under this role?
Number three under implementation. I think because this is a state bar standard and not a Public Defense Commission standard, doesn't talk about actually caseloads and attention to cases. But my understanding of how the practice is for most court-appointed PCR counsel, it seems to me like a real issue that should be incorporated in standards.
Well, I think that's up in 6.1 at paragraph 3. Is that kind of what you're thinking?
I'm trying to remember if that is something that we put in at the beginning of this. Because there are some, we did end up putting some qualifications. Yeah, caseloads. All attorneys must commit to providing competent and effective to each client.
Yeah, thank you for pointing that.
Yeah, no worries. I mean, and that's like, there's going to be some interplay here. I remember there's a lot of stuff that we talked about in the framework of qualification standards. They were like, no, that's more of a performance standard issue. But there are some that we pulled back into like the opening and being like, no, this is critical enough that it's everybody needs to. Okay.
I don't have a problem. This is what I'm envisioning. So we're basically not going to do 6.1 because that's already in the other document, the qualifications document. But, we can just pull paragraph 3 out and 3 of 6.1 out and put it under 3 of 6.2 and just, this is just a draft. We can always take it out if we feel like it's too redundant.
Okay.
And one thing I think of note that I brought up with the qualification standards internally, and that I think the criminal standards are going to reflect, is that repetition sells these things. So if there's something that you guys think is vitally important, like having a reasonable caseload might be, feel free to include it in both places.
Right.
Yeah, and I feel like with post-conviction, the caseloads can get out of control because you're not in the timelines aren't as tight as in a criminal case, and so people can end up taking a lot, in my opinion, more cases than they actually have time for, just because they know that they can ask for extensions. So I think it's worth repeating.
And even along those lines, the additional detail that is in this bar standard of 6.1, not only I completely agree with what Ginger said, and also just how vastly different, kind of with criminal cases, we can tell the seriousness of the charge and some of that kind of weights how significant it is. I mean, I can take two different homicide PCRs, and one of them might be a 6-hour case, and one of them might go on for years and last. So you just can't judge it, and it can be so vastly different what kind of case it is, and you really don't know that at the appointment stage usually. So that's what I think, if that's what we're impressing upon the powers that be that fund these things and decide these things, as well as the attorneys who are taking them on, I think the more sort of detail about how many a person can reasonably handle is something I think a lot about. I'm not in a contract. I do only hourly basic work. So I think a lot about what that's like to try and manage a case that was a serious underlying case, but the PCR isn't going to be very intensive, and another PCR that could go on for years and really intensive, litigation, discovery and stuff.
So when thinking about like how to organize this, and anybody can override me, so please, I will not be offended. I'm just thinking maybe we should go through these implementation paragraphs and see if we agree, and if we want to add something else into them or take them out. Seems like that might be a place to start.
Stamps that I can use. Oh,
Yeah, that's good.
let's not do that. Well, there we go. Can I do? Hey, I can. All right. So that should be easy. I can literally go through and mark up this with check boxes, I guess.
Although I really do like the Montana one also. That's really straightforward to me, but we can look at that and maybe add in something from the Montana one.
Yeah, I like how sort of simple and straightforward the Montana
I
one is.
do too.
This one's like a little bit unruly, but it is thorough.
I mean, Montana did have an extra 5 years before that one was created. So,
well, I guess let's decide on that first. Do we want to work from Montana's, or do we want to work from the bars?
I haven't reviewed Montana's yet, but I will say, Ginger and Meg, you having looked at that, if that seems more comprehensive, then I would side with you on that.
Well, the OSB one is more comprehensive. It's just also more cumbersome, whereas the Montana one is much more straightforward, in my opinion. I think it's only how many pages is it?
2 pages.
Yeah.
And I think I know Oregon's pretty well. So if we're working from something more limited, if something strikes me as missing from that more streamlined one, that may be a good place to start. One that's just more hitting the basics and streamlined.
Okay. So sorry, Kevin, let's go to the Montana one instead.
you're good. You're good. This is why the work group exists. So, okay, so let's start with the Montana one. What I see is that there's topics that come up. It's very sparse as to how it deals with them, but it's pretty good at laying out some of the big pieces. So, tell me what you want to do with this.
Yeah, could we use the Montana and then kind of fill in some detail from the OSB maybe, or
absolutely?
Okay, so the Montana one doesn't have any of the information as far as I can remember, and just kind of looking at it briefly, it doesn't have any of the information contained in standard 6.2. So let's look at 6.2 and see if there's 6.2 with the addition of paragraph 3 from 6.1, and see if we want any of this information to in the Montana one.
Okay, let me see if I can put these. Can you guys see these if I put them both on the screen at the same time? Like, is that feasibly readable?
I mean, I just have it up on my screen, so
Sure.
That's fine with me.
Okay. So from 6.2, what we want to add, sorry, how do you want to do this?
I think the 6.2 would go above the handling the case for Montana. If there's anything that we want to add in from 6.2 to Montana's. I mean, do people like this these 7 paragraphs in implementation? Or is this too similar to the qualification standards?
I like at least some, I mean, some of it seems like kind of the first few paragraphs, maybe the first 3 seem so basic that maybe they're unnecessary. I think paragraph 4 and
I like 4. I think that needs to be emphasized, that this is the first and last.
Yeah. And does that talk about federal, or is that later? Maybe that's in a different one.
In terms of timelines too, because we have a UTCR that, generally in almost all cases sets forth a pleading deadline, and that, I wonder if we'd want to, incorporate that in.
I think that's a
even
great
just
idea. Yeah, because I think what I miss sometimes, and I have to ask for not as much anymore, but is that 60-day deadline for witnesses. So I think that's really important to call it out.
Okay, so can you walk me through what you want in as the standard?
So I think like where it gets to be, it's time out, or C, I guess, promptly reviewing, instead of saying promptly, maybe even, noting you've got a pleading deadline, you must do these things before introducing your pleading. Like Ginger's talking about, you've got a request for witnesses, a notice of witnesses within a certain date. But rather than just being so general, he'll incorporate some of the specific rules you'll deal with in an Oregon PCR.
But I think that's going to come later on. I think right now we're just looking at the 6.2 and the standard, like the name of the standard that should go along with 6.2's paragraph 4. Is that what you're thinking of, Kevin? Like we need to know what standard paragraph 4 is attributed to.
Okay, sorry, I'm trying to annotate as we're going so that I can keep a record of what some of these comments are, and I will see what I can do over this next week to like pull a bit of a draft together and make it gel. So sorry, Ginger, can you?
Okay, so I think we need heading before number 3 on the Montana public standards. So like a 1 or a 2 at the very top.
Yeah. So at the very beginning, so we'd have like a role of the council, of council, or a handling the case, or however you want to. Okay.
Right. And so
if we did sorry, go ahead.
In the paragraph above handling the case is where I think we want to start with this number 4 from OSB.
Gotcha. Okay.
And then I think we should, or is it number 4? I think we need to look at number 4 and see if there's any other claims that we want to call out in this list that they have. So competence of the defendant, police and prosecutorial misconduct, judicial misconduct, eyewitness. I mean, are there any other like big ticket claims in post convictions that aren't in this list?
Well, yeah, depending on how there's a case at the Supreme Court coming up about whether innocence, like actual innocence
Yeah.
claims.
It's a great point.
So that may or may not go in. I'm not sure. Probably won't know that before the end of the summer when this.
So would this be something like checking the record or consulting with the client to determine whether any of the following claims might exist for relief?
Yeah.
Can we not keep it just as the way the number 4 is written?
Sure.
And just have that as its own. I think that could go under like role of post-conviction counsel, like a number 1 role of post-conviction counsel. And
I
this
know.
is, sorry.
I interrupted you.
Oh, I don't know. Just like before handling the case. So as a section, another big section, like role of post-conviction counsel, and then paragraph number 4 is like A under that. If we're editing the Montana ones.
So so the Montana 3A is a part of role of counsel. I'm saying
there should be, there's handling the case, right? In the Montana standards, there's handling the case, and then there's a bunch of standards. I think we should have a different section that's not handling the case, but like role of counsel.
Right. Okay. I got that part.
And then like A under role of counsel is going to be like paragraph 4 from OSB.
Yeah.
Does that work?
Yes.
And so in that list, under paragraph 4, I think we need to add failure to hire experts.
Oh, yes.
And then do we want to get as specific, like, and say failure to properly object to questions of, evidence, or failure to object to opening and closing? Like, do we want to break it down?
We could make a lot of subs to that ineffective, inadequate assistant of counsel, including what you mentioned. We could do several subs there.
Well, let's at least make a note somewhere that we want to add in to this list contained in paragraph 4, failure to hire experts, failure to properly object.
I will show you the notes that I'm taking. Question is just, do we want to be granular about what those look like?
Yeah.
Okay.
Yeah.
At least we're calling the question, and then we can answer that later. It doesn't have to be a now.
Yeah, and I mean, I think that it is broken out in paragraph 4. I just think that there are additional things that we can add.
Okay. I want to take a quick moment just to double check. I had heard that these first, at least the first 2, it sounded like you guys did not want to include as explicit standards because they're too general. Is that right?
Too basic? I think so.
And I think we felt like those were contained in the qualification standards.
Yeah. Okay. Cool. I just wanted, before I did anything, I wanted to make sure.
And then same with 3. So 1, 2, and 3.
Yeah.
Okay.
And apparently these are for sign here's, and I don't care. It's an X and a check mark. I'm just using them for that.
Looks perfect to me.
Okay.
Oh, so there, paragraph 5, Meg, is the.
Sorry, one more thing for 4. What we want to say besides juror misconduct, something like juror qualification.
Yeah, because we do want like Batson challenges.
Oh, sure. Yeah.
Yeah.
which may go to prosecutorial misconduct, but I feel like
Mhm.
I feel like if you're gonna say juror misconduct, you should probably also be considering qualification.
Okay.
Well, and maybe later on we'll get into some transcript stuff, and so we can just also add in that they need to be requesting voir dire transcripts and reviewing for error.
Okay. Yeah.
Do we want that? Okay.
I mean, we can put what Ed was saying into this paragraph 4, but I was just saying to pick it back up, we should remember to put that into what people are expected to gather.
Together. Yeah.
Okay. I will add that note. Okay. Okay.
And I think 5 could go in with like a asterisk that we will probably
Yeah.
need to update that.
Okay.
And I think paragraph 7 is good too.
And so that would all be part of the role of the attorney.
I think for right now.
Yeah.
Okay.
What about, do we want to call out the difference between a post-conviction petition and a petition for DNA testing?
Yeah.
Okay, so
Is the DNA testing thing, is that like an actual innocence challenge?
it's complicated.
Okay.
It's just a brief overview. So if you file a DNA petition, the DNA comes back, you're allowed to test the DNA comes back as helpful to your client, then you move for a new trial.
Okay. So it's a category of PCR-ish?
I mean, it's in the PCR statute. It just, yeah, I would say a category would be the right way to say it. But it's
Okay.
different than just a regular post-conviction. It's a completely different statute. So
Do we want to make that a substandard of these practice standards, or do we just want to say these rules aren't applicable to? Because I don't know. I'm appointed to one right now, but I don't know what OPDC's real policies. I heard the consortium doesn't handle those. I don't know what the actual rules are as far as having court-appointed counsel for those.
it's statutory. It's in the DNA statute that you get court-appointed counsel for it.
Do we want to make a substandard for? Is that what we're alluding to, Ginger, or just?
I think it's important to call it out. Maybe I'm not sure how to do it. When you say, you're not talking about a qualification standard, you're talking about the practice standards, I'm assuming.
Yeah, as far as performance, I mean, we want to be more specific about what needs to, how performance is handled in those.
Yeah, I
or
mean,
we just say,
I think so, if that's what we're tasked with doing, and what you do in a DNA post-conviction is totally different than a normal post-conviction. And I think that we should probably loop in Janice Perkel to help us with that. Because that's who I have to use to help me through them.
That's a good idea.
So maybe let's just make a paragraph for it and then confer with Janice on exactly what it should say.
Okay. I've got that note.
Okay.
Okay, and I pulled up the qualification standards just because I want to double check. Our current PCR like the new ones, you would be authorized to take any cases under Chapter 138 at the lowest level PCR attorney qualification level. Is that appropriate for DNA cases?
You're not dealing with civil rules, right? I mean, it's part of the criminal case, so you are dealing strictly with criminal procedure.
I don't know. This is why I really need Janice, because the only DNA petition that I have filed, it was in the underlying criminal case, but I think that that statute may have changed for you to file it in. Meg, do you know, do you now file it under a new post-conviction number?
I don't know. We don't get those. Yeah.
Okay, let me look. And you guys can keep talking about something else while I look this up really quick. Yeah, I mean, I served the district attorney. Yeah, I'm not seeing anything in my quick review of that. It changed in 2023.
Okay.
But I can find out that question if it goes, I don't know if it matters to us, if it goes back to the criminal.
Well, so, I mean, the question is really, from a qualification standpoint, is this something that we want the original, like, do we want it falling under the criminal appointment standards, or do we want it falling under PCR standards? Because we
It
can
should be under
define.
PCR standards.
That's
for sure.
kind of where I thought. So if we're talking about a language change to say petitions or motions under Chapter 138, it says post-conviction relief proceedings, and that could cover both. I just want to make sure before, because we hadn't really talked about DNA petitions, if we needed to move that, the commission has not yet adopted them. So we can flag that as a last minute adjustment that's needed. Just
yeah, and you could just say motions under 138-692 or 138-690.
I mean, I don't know that we need to be explicit.
Okay.
If this
Okay.
already covers, my real question is, do we need, are such petitions used in other than murder or aggravated murder underlying convictions? And B, if not, because, or if so, do we need to break those kinds of petitions out specifically for a higher level than intro level PCR, right? Like, are the DNA petitions too complicated at base level for someone who's not murder or ag murder PCR qualified?
Oh, that's a good question. They're, in my opinion, they're complicated. But I don't know, Ed, what do you think?
I don't think you can underqualify for this, especially because, like, it's not a well-known process, well-known procedure. I mean, I have one right now just because we're interested in, global representation for this client. But yeah, I'm not even qualified to speak in detail what it needs. But even the fact that it's not a well-known practice or well-developed, body of procedure, the more you know for handling that type of thing, the better.
Mm-hmm.
Okay.
And so I'm looking at this, it doesn't look like it's no longer filed into the underlying case. it's filed as a standalone, proceeding. Is how I just recently did it, as opposed to filing it into the underlying criminal case.
Okay, so that's fine. We can go ahead and.
Yeah, I just was letting Ed know that what I said was incorrect.
Okay, cool. Then we can, hold on, let me see if I can pull practice standards back up. Okay, so what I have so far is a role of counsel section that is OSB paragraphs 4, 5, 7, and talks about the difference between DNA testing PCRs and other PCRs. Is that where we're at this point, and want to move into like the next phase, which would, under the OSB standards, be communication, and under, or are we moving into handling the case, which could include?
Yeah, I think 3A
ahead.
seems like communication.
Yeah.
Kind of getting started with that.
But did we finish going through 6.2? Do we want to leave in paragraph 6 and paragraph 7 of 6.2?
I have 7 marked as something we wanted to bring in. I don't have the stamp on it. I just didn't get to that part. I don't have 6.
Okay, that seems like a qualification and a conflict.
Yeah.
I mean, that's
Yeah, I'm not sure that we need to necessarily explicitly say don't.
That's an
Don't take
ethics
a case
issue
where
right
you-
there.
yeah.
I mean, 7 is important for people to understand. I just don't know if I personally think it's worth highlighting that.
Yeah, I think so too.
I would definitely have that information somewhere in the standards. And Kevin, does OPDC have some standard about appointing appellate lawyer who was trial lawyer, appointing post-conviction lawyer who was trial lawyer? Is there something already in the rules for that?
I don't believe that there is. I don't think we've ever explicitly needed it. But I don't think Meg, you're on the contract for PCR, right? So, and I think there's,
only for appeals.
Right.
I have a contract. Do you want me to look at it?
I mean, double check. I can pull up contracts too, but I don't know that it explicitly says anywhere, because if I'm remembering right, we just use the base level criminal contract, where that wouldn't even be like, that wouldn't be a thing. That wouldn't be a thing that we would have had the foresight to put language in the contract about. I think we're really talking like this is a standards issue. We can certainly include it, just to be real explicit that, hey, no, you don't get to handle your own ineffective assistance of counsel claim.
I would be really sad for the state of Oregon defense attorneys if anybody thought that they could.
Well, the state bar,
let's not.
They need to call it out. It's like
That's true. Should it go into the qualification standards?
Qualification standards is like, what is the bare minimum qualification for you to work on this practice area? This is more of a case specific thing, which I would say is a practice standard.
Well, do we have a page limit?
Nope.
No.
Okay, then just put it in.
Let's put it in.
All right.
I think if you guys think it's a bad idea for someone to do, we should put it in there that it's a bad idea for someone to do.
Yeah, I mean, it's not ethical.
It's definitely a bad idea. Yeah.
And I could conceive of people not necessarily understanding. I mean, I would hope they would, but without being told that, yes, it is a conflict.
I
for
mean,
you
I
to
can
represent.
envision a situation where you're trial counsel and the only claim is a prosecutorial misconduct. So you think you can represent them, but you can't, because you still need to consider the whole record.
Right.
Yeah.
Well, and you're unlikely to think, I mean, depending on who you are, you might be unlikely to think you did anything wrong.
And clients don't necessarily understand that either. So it could just be helpful to have that in
Yeah,
there.
that's great. That's a great idea.
Cool.
Okay, it's in.
All right. It sounds like we want client communication as another topic area.
As a separate one, definitely.
Okay. Okay, it looks like the overview takes into account that first, so the OSB overview for 6.3, upon appointment or retainer, yada, yada, get in touch with your client, which sounds like that's basically 3A for Montana.
Yeah.
How do we want to be more explicit about what that contact needs to look like, and how soon, or what the time frame is? For instance, under the current contract, there are specific, like, you need to send the first letter or make your first contact within 24 or at most 72 hours. And then first interview, I think, depends a little bit on the practice area. Are there specifics that we want to put in here?
That's just hard.
Yeah, it varies a lot of when you get materials from previous counsel. It's hard to get in. And believe it or not, I have clients who are not in custody, PCR court appointed.
Mm-hmm.
So you have, it differs by facility, it differs by a lot of different things. So
I mean, I think that you should, well, what we do, and I don't know if it's worked for us, is that within 2 weeks of appointment, we schedule the initial telephone call. But that, depending on the institution's availability, that could be 2 weeks, an additional 2 weeks out. So I would feel comfortable saying within 30 days of appointment, you need to have your first contact with your client. I mean, to me, that, in my experience, that has cut down on clients' frustrations.
Mm-hmm. And what do you mean by first contact? Are we talking sending out the letter of how to get in touch with you?
No,
or...
I would say like talking to them either on the phone or in person.
Okay, let me move this onto the screen. See. Okay.
I don't know, Ed, does that seem too much? I mean, as soon as, again, our office does things, as soon as we get the appointment paperwork, we send it to the client with the release forms. In an introductory. Well, I suppose it probably differs. Sometimes we might just send out the notice of appointment and then follow up with the release forms, if we don't know who represented them. But I mean, it's our practice to immediately send out anything that we get from the court. So that just includes the appointment of counsel. So when I'm calling them, it's not completely out of the blue.
Mm-hmm.
They at least have that paperwork. So I don't know. I think 30 days is sufficient. But Ed, how do you feel about that?
yeah, so I don't have nearly the practice and experience that you do, Ginger. It's worked pretty well for me that I send the release out right away and get that going. And then, I usually try to have a phone call within a couple of weeks. But I don't think 30 days is unreasonable. If you say within 30 days, you've either personally met or had a phone call.
Yeah.
I think I wouldn't want to wait that long to send like a release. Hey,
No,
here's
I totally agree.
Okay. Do we have a set number of days that we want to look at having that notice of appointment and request for releases?
I mean, it's like immediate upon appointment, so I don't know. 7 days?
Sure.
If I'm in the middle of a jury trial, it might take me a little longer, but I certainly try to do it within a week, but there have probably been times when it was maybe closer to 2, depending on
Yeah.
what was going on.
Right.
Okay.
2
Fair.
weeks then? Or do we want to have a document that micromanages this much? I don't
I
know.
know. Yeah, I know. Or just like upon appointment, send those things. Could you say something like that?
Sure.
Yeah, it's just hard. Is this an enforcement document or is this a help people practice better? Because if it's something for OPDC to, enforce, then when you say upon appointment, it's so squishy.
Well, definitely, yeah.
Yeah, so what's the purpose of this document?
That's
Just to outline how a good post-conviction practitioner should practice? Or is it for OPDC to say, look, you didn't do this, this, or this, and so this is what happens?
So you have hit on the probably most important question, which is, yeah. So my understanding is that it's somewhere in the space between minimum standards and aspirational. The problem being, there's not much in this sphere, not as much in this sphere as there are in other spheres, which means that there's not anything else to refer to for minimum standards or things along those lines. However, currently under the contract, the OSB standards are used as contract terms. The contracts refer to those OSB standards, and they are subject to the enforcement capabilities, such as they are. And we anticipate that the same will be true of these when they are finished, is that they will be referred to as part of assessing performance.
The
of
OSB standards are
Mhm.
currently part of the contract.
So it's weird in this
Are they
space.
enforcing them at all?
Yeah. Well, there's the other part of it is what bandwidth does our agency have to enforce them
Yeah,
currently? And that
exactly.
is the other, like, that's the flip side of this, is that they are meant to be, yes, this is what good lawyering looks like, but also reasonable in the frame of what does OPDC have bandwidth to actually do? Because having an enforcement mechanism that we don't have the bandwidth to actually engage is difficult. So
So would it be
that
more helpful to like have something that is what we consider the like very bare minimum, that's a much simpler document
I
that would
mean, so
actually get enforced?
the
Or
the
is-
numbers are very helpful for enforcement.
Yeah.
That is the key piece, is because while we may not be, like, the goal here may not necessarily be performance metrics, that is a goal that we have, is developing performance metrics that eventually, and I'll be blunt, the direction that things seem to be headed is that all attorneys doing any work under contract will need to do timekeeping. And those who, I mean, in a way, everybody who's doing hourly work already is, because they submit bills. We just don't have it quite as data crunchable as work done under a contract, except the PCRP juvenile contracts, which all do currently require timekeeping. So that is something that is going to be wider, more applicable to more providers, is my understanding. It's not, I don't know how soon, but that is where things appear to be headed.
Okay, so then I think we need to put in 2 weeks.
Sounds
Because I
good.
think, I mean, I want OPDC to be able to get rid of providers that aren't properly representing their clients.
Me too.
Right.
So I think 2 weeks, and then
And I will note that enforcement is not always penalized, like penalties. What we
Sure.
are also, like, we added training and mentorship and other forms of let's get you where you need to be into the enforcement mechanism that the commission voted in last month, I think. So that that is also part of where we're headed, is we don't want to just get rid of people. We want to help people be the attorneys that we need them to be as well. So
Fair enough.
yeah. Okay. So we have the habeas group starting
Okay.
scheduled to start in a couple of minutes. And I know that we had said we wanted to make sure that there was a break between both PCR and habeas. So I'm going to go ahead. This seems like a stopping point. Whether it's a good one or not is a completely different question, but it seems like a stopping point. So we'll take a quick break, and I will start that group at 12:05. Okay? And if you're late coming back to it, totally fine. Don't worry about it.
Is
so-
it a different link or is it the same?
It's a different link.
Okay.
Yeah, it's a different link. All right. Thanks, everybody.
Thanks, guys.